Yes, we can.
Great. And you can see the presentation in the background. I can't see what is there.
We can't, but it's going to come up momentarily.
Okay. Well, I'll just go ahead and get started with a little introductory comment. Thanks so much for that introduction. My name is Laura Ridolfi. I'm really honored to be here this morning to talk about pre-adjudication detention and depopulation. For those of you who are unfamiliar with the Burns Institute, we work towards what we call structural well-being, reimagined system of public policies, institutional practices, and cultural norms that work together to strengthen families, communities, and individual outcomes. It's really a direct challenge to an operational framework of structural racism that really drives what currently happens to young people in systems like this. And here in LA County, the Burns Institute has been a partner in Youth Justice Reimagined for many years and in the ongoing work of transformation. So our goal organizationally is not just to shrink a system, it's to transform it. Decarceration, genuinely moving young people out of incarceration and into communities is a critical step in that path, but it's just a step, it's not the destination. Youth Justice Reimagined asks a deeper question, not just how do we get fewer young people incarcerated, but how do we build something worthy of them instead? So today I'm going to talk a little bit about depopulation because it matters urgently and because it's within reach, but I want to hold both truths, the work of reducing harm right now and the work of building a system that we actually want. You can go
Laura, the presentation is up on the screen. So if you just want to note while you're talking to have us go forward to each slide.
Great. Go ahead and go to the next one. Before we get into local data and strategies for depopulation, I want to ground us in why this matters. Detention, even short-term pre-adjudication detention, disrupts adolescent development. It increases the risk of depression, self-harm, suicide. It makes it harder to return to school, reduces the odds of graduating, and it's a strong predictor of deeper system involvement. We're not holding youth in juvenile hall and releasing them unaffected. Every single day a young person spends in pre-adjudication causes them harm, and the harm that's happening is not being distributed equally. Black, Latino, and Indigenous youth really bear the brunt of the system in ways that white youth simply do not. They're detained at higher rates, they're held longer, and pushed deeper into a system that was never designed for their well-being. You can go to the next slide. Getting to detention requires passing through multiple gates, and at every one of those gates, the law provides an off-ramp. Every one of the boxes that you see up on the screen shows what those off-ramps are, and it tells you who's eligible for release at each stage. And what I'm going to show you is that LA County right now, in the county, those off-ramps are not being used to the extent that they could be. In many instances, they're really being bypassed as a matter of practice and local policy. You can go to the next. So the first gate belongs to probation. Just want to ground us in what the law says. When a young person arrives at intake, the law is really unambiguous. Probation must immediately release a young person to their parent or guardian unless two things are found true. First, that continuance in the home is contrary to the welfare of the young person. And second, that at least one of three grounds exist: urgent necessity for protection, a likelihood to flee, or a violation of a court order. That's it. Those are the only grounds for detention. Otherwise, it is presumed that the young person should be released. You can go to the next. At the detention hearing, the judge applies a similar standard. All three elements that you see up here must be present. And even then, the court first has to consider whether available services would prevent detention. And here's how this connects to probation. The judge is working from the detention report that probation writes. If that report doesn't recommend release, if it doesn't even raise release as an option, the judge is starting from a document that presumes detention. And so it's critical at that stage that the judge has all the information that they can and all the resources available at their disposal to ensure that the young person can be released as it's aligned with the law. You can go to the next one. So I'm going to get into a little bit of data, and everything I'm going to show and talk about comes from 3 sources. All have been produced in the last 6 months. The Probation Oversight Commission's intake detention analysis from February, probation's response to that analysis from March, the Office of Inspector General's assessment of the 135 detention reports from March, which also draws on the LADS risk assessment data in a report that was put together by the Oversight Commission. All of this, it's not outside advocacy. These are all from internally from Los Angeles County. This is the oversight and accountability that's doing exactly what it's supposed to do. And what all of these found is that there are really good opportunities to advance the depopulation plan. You can go to the next one. So as you likely know, the probation oversight's analysis found that detention is functioning as a default. Serious offenses, 707B cases dropped from 61% to 36% of intakes between 2024 and 2025, but the detention rate hardly moved during that time. Serious offenses nearly halved, but the detention continued. And overall, 72% of young people were still recommended for detention at intake. And for CDP, the conditional detention alternative represented only 21% of intake outcomes on average. And when it was used, it wasn't used immediately. In 2025, 98% of the CDP cases were still detained at first at intake. So CDP is functioning as a delayed release mechanism, but not as an immediate alternative. You can go to the next one. And probation's response to the Probation Oversight Commission raised some real constraints on their ability to depopulate. And I want to acknowledge them because they're legitimate. The DA charging decisions and court stacking, transfer motions that tripled in a year, a very long length of stay for transfer hearings. But the court order, population target of 175 at Los Padrinos, currently sits far above that. And the DA and the courts are absolutely contributing to the problem. But this is the through line today. There are still decision points that remain within probation's control that are not being utilized to the extent that they could be. And that's what we'll get to. You can go to the next one. As you also mentioned, and I think it sounds like we'll hear more about later, the OIG report that was released was an assessment of 135 reports, and every report, from January of 2025, none of those reports recommended unconditional release. None, zero. And the OIG also found a general bias in favor of detention. That is the language that they used in the report. They found that decisions reflect subjective judgment of the reporter and not objective criteria, that there were factual errors. One young person was falsely marked as a 707B offense, but it was his first time offense. Another had violated a court order, but it was his first arrest. They found that the LADS score, the risk tool that probation uses, never reached the judge. So the judge has no idea whether probation's own risk assessment analysis supports the recommendation that's in front of them that day. You can go to the next. And going back to a report from earlier that you likely remember, here's what that tool actually showed from an analysis in December of 2024. Of the 521 youth in custody on that day, 100 or about 20% scored low risk. So the OIG would suggest they release, and the tool would suggest they release. Almost half of the young people scored a medium score. So the OIG and the tool would suggest that they be considered for CDP. That's well over half, 63% of the detained population that was scoring low or medium using the probation's own tool. And even among youth accused of 707B offenses, 66% scored low or medium. So, just noting here that although, as we talked about earlier, mandatory referral to custody, for those cases initially doesn't mean that probation cannot recommend release at the detention hearing. When the judge is seeing the young person, they fully have discretion to make a recommendation for release. And that is an important distinction, and that really matters as we move forward. You can go to the next one. I want to pause for a moment too, just to talk about the risk tool generally, because the Burns Institute, has a position on this. Risk tools are an important way to create objective mechanisms for reducing population, but they're not neutral. A tool that's built on prior arrest data inherits all of the bias of a system where Black and Latino youth are arrested at higher rates for the same conduct. So even a well-designed risk assessment tool can reproduce inequity under the cover of objectivity. And that doesn't mean the LADS data isn't useful here. It is, it's important, but accepting that high risk as a justification for incarceration means that we're accepting that incarceration is the best response to those young people. And we really believe that there's a different answer to that. And I'll also add on a personal note, in 2009, I wrote a memo to the LA County Probation Department raising concerns about the LADS before it was implemented. Part of what drove that memo was a very high override rate on the former tool, the Chrisberg scale, that the LADS was meant to replace. It had an 84% low risk youth who were detained based on it, and 92% of those overrides were youth of color. So we warned that a tool built on prior arrest would inherit that disparity, and that's exactly what was found in that OIG report, and that found that subjective judgment overriding objective scores, zero conditional release recommendations. So that same pattern that we were noting is happening here using a different tool. So just noting this is an important piece of information, but we need to be digging deeper and finding out more about what's driving detention as well. You can go to the next one. I want to, there's been many strategies I know that you've talked about in this space, and that came out in the report, and that I'll talk a little bit more in a moment. But I wanted to highlight one additional strategy that I don't know you've talked about in this space before that's happening in San Francisco. They have something called DDAP, the Detention Diversion Advocacy Program, that was designed specifically for young people who are charged with serious offenses, who would otherwise be detained. Case managers build individualized release plans and present them to the court immediately. And they did an independent evaluation of that program and found that young people who were remained in custody were 1.5 times more likely to have a new case than kids who were on the DDAP program, and were 2.3 times more likely to receive a subsequent felony referral. So this is, just an important strategy to think about all the different ways in which, depopulation strategies can borrow from other counties that are doing work with that same goal in mind. You can go to the next one. So I want to go back to sort of, what is and is not in control of probation, and what the commission could ask of the department. And we talked about that there's a lot of different drivers of detention that probation can't control. But there is also a lot that they can control. First, release and CDP recommendations practices, having zero unconditional release recommendations in 135 reports is not a DA outcome or a court outcome. That is a probation outcome. So one recommendation or idea could be to require justification in written form that considers release consistent with what Welfare and Institutions Code Section 628 actually requires. And separately, CDP, it represents only 21% of intake outcomes. And like I said, in 2025, 98% of those were detained at first. So thinking about how do we monitor that data and report it monthly or, on a regular basis to this commission to find out what's happening and not just a one-time snapshot to look at. Second, whether the LADS score ever reaches the court. Officers obviously use this assessment at intake, but it's not reaching the bench. So the judge has no idea whether probation's own tool supports the recommendation that's in front of them. And this is a policy choice, not a legal mandate. So, think about a policy that would require the full LADS, so that the judge has information about what's driving those scores, again, to ensure that bias isn't driving a higher score. And then the final score in every detention report given to the judge, the DA, and counsel. Third, looking at the categorical detention policies and overrides. Probation has created internal categories and treating them as mandatory detention triggers. They're not. None of the categories are required under Welfare and Institutions Code Section 628. The law actually requires individual assessments. And there's 3 grounds: urgent necessity for protection, likelihood to flee, violation of court order. That is it. So when probation says a category of offense requires detention, they're describing a policy that they created, not what's the law. So I'd recommend a review of those categories and ongoing monitoring to ensure that every decision is justified against the actual statutory standard. Fourth, the quality and accuracy of those reports. As was noted, there's errors, inconsistencies, misapplied standards. Judges rely on those documents. So, considering, as the report shared, training, ongoing auditing of those detention reports, and requiring a written justification for any report that doesn't consider release consistent with WIC 628 and what it actually requires. And then fifth, case reviews. The Board of Supervisors directed probation to conduct ongoing reviews of youth detained pre-adjudication. And as you heard from Lisa Macaluso, I think probably a couple of years ago at this point, this kind of ongoing review is really a cornerstone of effective detention reduction and expediting that process. So, continuing that process and making sure that those that review and the data from that review come back to this commission for reconsideration of how that's going and where tweaks need to happen. And that is it. I have all the information I have for you today. I think I'm at my time too.
Okay, thank you. Thank you so much for that presentation. Commissioners, before we move on to our next presenter, does anyone have any questions or comments? Yes, Commissioner Harris.
Thanks. Hi, Laura. Could you just unpack a little bit more the categorical policy detention and overrides idea? I think that's something that that we hear a lot on the commission from the chief and probation, that they are responding to statutorily to, that their hands are tied. And I'm wondering if you could just dig in a little bit more for us and the public about that idea.
Sure. So there's in the tool itself, there are certain reasons for detention that are not statutorily required, but that are determined based on policy of the department, that a young person who comes in with those offenses or conditions will be detained regardless. I don't have the labs up in front of me. Maybe you all do, but I believe one of those categories that frequently includes overrides or mandatory detention are things like domestic violence and other issues where a young person can't go back to their home. There's certainly strategies for a safety plan or a release plan that could accommodate young people who are accused of offenses, DV offenses, a whole host of other mandatory reasons that there's not an investigation further around what could we do, what kind of safety plan or release plan could we come up with for this young person, so that detention isn't the default. And those are places where things like a DDAP type program, where rather than just going through a checklist and checking the box if a young person meets one of those mandatory criteria, we're going to detain them. Really having someone who's dedicated to thinking through what are the what alternatives are available that we can think about to not detain that young person. But I think it would be great for this commission to unpack those mandatory detentions and to get a report that looked at on a regular basis, sort of broke down which of these young people are held based on a risk score, and investigating that. Like I said, I don't think that a high risk score should necessarily mean that they're always detained. But for low and medium scores in particular, if there's a discretionary override reason, what is it and what can we do for a release there? And if it's a mandatory policy, what is driving that mandatory policy, and what can we do to expedite release for those youth as well.
Thank you for those suggestions. Any more questions or comments? Commissioner Kakani?
Okay. Just a question about the SF DDAP program. Is that a separate branch within SF San Francisco's probation department, or is that like a separate
It's a separate
department?
It's a separate, it's a nonprofit organization, the Center on Juvenile and Criminal Justice. They have mentors that partner with public defenders and come in immediately to help build a plan for a young person to be safely released from detention.
Got it. And then present that to the court.
Yes, present that to the court.
Okay. And then as it relates to overrides, do you know if there are any other counties, probation departments or courts or whoever it is that shares kind of some of this data? If there's like a dashboard that we could look at as a model?
I don't know off the top of my head a dashboard that's a model, but there are definitely counties that share that information regularly. Many, Lisa, when she came to talk to you, she was representing the Annie E. Casey Foundation, and they've done a lot of work with risk assessment instrument tools, in hundreds of counties across the country. All of those jurisdictions collect data in a really strategic way that look at the number of young people who are detained, the reasons for their detention, the overrides, the override rate, and all the reasons behind it. So, and deliberate on that as a collaborative body that includes judges, probation, community, so that everyone can see the data, raise alarm when there are high override rates, and collectively think about what can we do to reduce this population, because there's, everyone sort of collectively agrees these kids don't need to be detained. What can we do to strategize around reducing that? So absolutely, it is a standard to be reviewing that data publicly in all of those jurisdictions.
Thank you.